Hey guys, my name is Mark J. Victor. I am an attorney with the Attorneys for Freedom Law Firm. And today I'm going to talk to you a little bit about what's this appeal I've been hearing about. Well, first off, if you're talking about appeal, things didn't go so well, right? Either you took a plea, like most people do in the system, in which case you waived your right to appeal, so you don't have an appeal. Sorry, you're out of luck on that one. Or you went to trial and things went poorly for you at trial, right? Because if you won your trial, you were found not guilty, and we're not talking about an appeal. So we're in the situation where you've gone to trial and you've lost, and now we're talking about an appeal. Well, the first thing you need to understand about an appeal is you don't just get a second trial just because you didn't like the first trial. You don't get to say, hey, I'm going to send a piece of paper to the Court of Appeals and I didn't like the outcome of my case, and they're going to say, okay, we'll give you another trial. That is not the way appellate work operates in Arizona or anywhere else, to my knowledge. What you can do is say, in essence, to the Court of Appeals, which you should understand is not the trial judge, but generally a three-judge panel. These are normally people who were trial judges, sometimes not. They get appointed to the Court of Appeals, and there are three judges on that panel. Sometimes you can have the entire appellate court listen to a case, but that's pretty rare. And so generally you're looking at a three-judge panel, and what you're saying to them with the appeal is, hey, judges on the appellate court, something about this trial was wrong, and that caused this trial to not comport with due process. It was an unfair trial. Things were done wrong. Common types of things that arise as appellate issues are things like jury instructions. Maybe the instructions to the jury were something was flawed about them. They didn't accurately explain what the law was. Something about how people got on the jury, whether people were struck for cause or not. Something about evidence that came in. Maybe the state tried to offer some evidence and the defense attorney said objection, and they had a big argument about it, and the judge said, I side with the state. This evidence comes in. That's the type of a thing that can be raised on appeal. Also, motions to suppress. There's another video if you're interested in looking at what a motion to suppress is that we have on our website. But say you filed a motion to suppress and the judge denied it. That's the kind of thing you can raise on appeal. So there can be many different reasons, but the point is you got to find a legal reason where you're saying to the court on appeal, something was wrong with my trial. Now, another very important point. At the trial, back at the trial level, if your defense attorney didn't raise an objection, like for example, if the state brought in evidence and the defense attorney didn't object to it, and now on appeal, you're going to say, hey, I got a bad trial because this evidence came in, probably the appellate court is going to say the dreaded word on appeal, which is waiver. Well, what does waiver mean? Waiver, in essence, means, look, you had an opportunity to tell the trial judge that this was a mistake right at the time of the trial. And if you didn't raise that, you in essence deprived the trial judge of an opportunity to fix it. So you've waived the issue. Now, this isn't completely fatal in an appeal because sometimes you can still argue, well, yes, even though it was waived, it's such a big error, it's such a fundamental problem with my trial that even though the trial defense attorney didn't raise this issue, it's still such a big problem, you should still give me a new trial. But that's a much harder argument. My point here is when you're having a trial, you got to make sure that the trial defense attorney objects and objects often and preserves the record. Us appellate attorneys, that's what we always say to the trial attorneys. Preserve the record on appeal so it's clear, so they can't on appeal say, oh, waiver, which is usually the death of your appeal. So in any event, that's the way an appeal works. And by the way, I should also note that if you lose your appeal, you may get another bite at the apple because you can then try. You don't have a right to appeal. You have a right to appeal to the appellate court, but you don't necessarily have a right for the Supreme Court to hear what the appellate court did. So you have an opportunity to say to the Supreme Court, hey, the appellate court got it wrong and I'm asking you to fix it. But you should know the Supreme Court takes very few cases. Now, one other last point here. When you appeal something, you always want to try to federalize the issue. What does that mean? It means that if you can make the issue that you're complaining about also a federal issue, not just a state issue, then you may have an opportunity, even if you lose at the Arizona Supreme Court, to go over to the federal court and start there with the district court and say, hey, they got something wrong in the state of Arizona. I'm appealing to the federal court to try to fix this. If you lose there, you can then appeal to the Ninth Circuit Court of Appeals in San Francisco, which I've been several times and argued and won there. Very interesting place if you ever get a chance to go to the Ninth Circuit Court of Appeals. So it's very important to preserve the record. An appeal, I hope you never get there because it means things didn't go so well. But I hope this gives you a little bit of an overview of what an appeal is. If you ever have any questions about an appeal or any other question that relates to criminal defense, always feel free to contact me. Again, my name is Marc J. Victor. I'm with the Attorneys for Freedom Law Firm. Thanks for listening.